Preferably, you're asking me this at a point in time where you have already secured a judgment that holds someone liable for having taken your money in an inappropriate manner. And what you have available are a series of post-judgment remedies that we can use and employ throughout the United States, in any state, and even abroad in most, but not all countries. The remedies are cumulative in nature. In the United States, if your judgment is a state court judgment, by virtue of the full faith and credit clause of the U.S. Constitution, every state must recognize it. Almost every state has now enacted the Uniform Enforcement of Foreign Judgments Act, which makes it a quick and simple procedure to have your judgment recognized in any state. If it's a federal judgment, we can do the same thing to have it recognized in state courts. We can register it in any federal district court in any circuit of the United States federal judiciary system. The most common mistake most people make when setting out to collect money is to start with the debtor. A lawyer who does not do this full-time or do it in the way I and a select number of other lawyers pursue it, will start by saying, well, let's send written questions or interrogatories to the debtor, and then let's haul the debtor in here and depose him, put him under oath and ask him questions in the presence of a court reporter. We typically do not start there. It's very unusual that we would. Usually we are considerably into a case before I even bother sitting down with a debtor. I mean, after all, debtors often lie. And if they're engaged in a course of fraudulent conduct, it's almost assured they will lie. And they're inevitably very likable and most of the time very intelligent and very bright. That's why they're so good at what they do. At some point, I'll describe for you what we call the pyramid of fraud, which is an interesting segment that will explain the mindset of someone who does fraudulent transactions for a living. So we start by circling around a debtor. What are the facts and circumstances of your transaction? What leads you to feel that it may not have been on the up and up? And then we do other research for where else has this debtor been? Who else has he affected? Does this debtor have other associates, partners, former partners? Does this debtor have a mole within his operation? Has this debtor upset other people who perhaps wish to share information with us? And then we do public record searches, and we start assembling piece by piece the information which we wish to examine a debtor about. This is the year 2017, rapidly coming to an end when this is filmed or videoed. But as you know from the news, you can watch federally what's going on with the U.S. Senate and the U.S. House and with Special Investigator Mueller. You hear, they go about this methodically. That's what we try to do. Your target, in this case, the debtor who ripped you off, is near the end of the food chain. That when we sit down with that debtor, we want to give that debtor every opportunity to lie under oath, preferably many times, because that positions us to, if you will, poison the well with the judge who handles the case. Many of these post-judgment remedies are discretionary with the court. Many we're absolutely entitled to as a matter of right and simply go in and request them, and they must be given to us. But when it comes to the discretionary remedies, which I personally oftentimes find the most interesting, I don't take glee in the fact you've been ripped off in the least. I do get enjoyment out of doing this kind of work, as you can probably detect in the manner in which I speak about it. But when it comes to these discretionary remedies, it's really nice if we can go in and really show the judge that your debtor is really a bad dude.